Before we begin, a quick and important disclaimer. The information provided in this educational series is for informational and entertainment purposes only and does not constitute legal, financial, or professional advice. Divorce laws, mediation protocols, and asset distribution regulations vary significantly across different states and institutional jurisdictions. The complexities of American academia, particularly concerning intellectual property and tenure-based benefits, require specialized professional guidance. Viewers are strongly encouraged to conduct their own due diligence and consult with a licensed attorney or a certified mediator specializing in academic or high-asset cases before making any decisions related to their personal or professional lives. Imagine for a moment a researcher who has spent 15 years in a windowless laboratory, securing millions of dollars in federal grants and finally reaching the pinnacle of their career, a tenured position at a prestigious Ivy League institution. Then, in the span of a single afternoon, they realize that their life's work, not just their bank account, but the very patents and intellectual property they've cultivated, is about to be subjected to the blunt force of a standard courtroom litigation. In the high-stakes environment of American academia, a traditional divorce is not merely a personal ending. It is often a professional catastrophe. Historical trends suggest that the adversarial nature of the U.S. court system frequently fails to account for the unique nuances of scholarly life, from the nonlinear vesting of university pensions to the intangible value of a published bibliography. We are currently witnessing a silent crisis in the ivory tower where the divorce penalty can result in the loss of research funding, the forced sale of intellectual rights, and the destabilization of departmental tenure tracks. This is the open loop of our modern educational system. Can a process designed for the general public truly serve the minds that are shaping our future? Or are we watching an outdated legal framework dismantle the brightest assets of our society? This deep dive masterclass serves as the definitive guide to navigating this specific, often overlooked intersection of law and education. By the end of this comprehensive discourse, you will understand how divorce mediation, specifically within the context of American academia, functions as a sophisticated alternative to the scorched earth policy of traditional litigation. We are solving a problem that has plagued the academic community for decades: the lack of a tailored, intellectually rigorous approach to domestic dissolution. You will learn the mechanics of how alternative dispute resolution can preserve research continuity, manage the complexities of TACREF distributions, and protect the sanctity of the academic sabbatical. We are moving beyond the surface-level tropes of family law to explore a specialized framework that respects the intellectual and professional identity of the scholar. To understand why this is a modern necessity, we must first examine the historical trends of the American legal system's interaction with the academic professional. Historically, the standard divorce model in the United States was built around the concept of tangible assets: the family home, the car, and the joint savings account. However, for a professor at a top-tier research university, the most valuable assets are often invisible. Consider the case study of a biological researcher whose pending patent was valued not by its current revenue, but by its potential impact on future pharmaceutical developments. In a traditional courtroom, a judge with no background in biotechnology might struggle to value such an asset, leading to equitable distribution rulings that are anything but equitable. Case studies from the early 2000s show that litigation frequently led to the freezing of research accounts during the discovery phase, effectively pausing critical scientific advancements for years at a time. Mediation offers a paradigm shift. Unlike a trial, which is a matter of public record, mediation provides a private forum that is essential for maintaining a professional reputation within a small, tight-knit academic circle. In many academic communities, a public and messy legal battle can influence tenure committee decisions or the perception of one's ability to lead a department. We will explore how mediation allows for the creation of custom-built settlements that address the specific timelines of the academic year. For example, a traditional court might order a house to be sold within 30 days, but a mediated agreement can be structured to allow a professor to remain in their home until the end of the spring semester, or until a sabbatical period concludes, ensuring that their teaching and research obligations are not compromised. Furthermore, the American academic pension system is a beast of its own. Most professionals in this field rely on the Teachers Insurance and Annuity Association and College Retirement Equities Fund, better known as TIAA. Unlike standard 401k plans, these accounts often have complex rules regarding survivorship benefits and mandatory distributions. Historical data indicates that when these accounts are handled by generalist lawyers in an adversarial setting, The tax implications can be devastating. Through the lens of mediation, we can look at potential outcomes that utilize specialized qualified domestic relations orders, or QDROs, that are drafted with the specific intent of preserving the long-term growth of these scholarly funds. We must also address the sabbatical factor. In American academia, a sabbatical is a hard-earned period of intense research and professional renewal. In a standard litigation, a spouse's legal team might view a year spent in Europe or at a sister institution as a luxury or a vacation, potentially influencing alimony calculations. In mediation, however, both parties, often with the help of an expert who understands academic culture, can acknowledge that this is a career requirement. They can negotiate how child custody or financial support will function during this period, without the need for a judge to interpret the rigors of a research fellowship. Step by step, this discourse will unpack the psychological landscape of the academic divorce. Scholars are trained to be experts, to be in control, and to find the right answer through rigorous analysis. This mindset can be a double-edged sword in a legal setting. It often leads to a desire to win an argument based on principle, which in a courtroom translates to skyrocketing legal fees. We will analyze historical trends showing that mediation is statistically more successful for high-intelligence cohorts because it appeals to the academic's desire for logic, efficiency, and a mutually beneficial outcome. It moves the conversation from who is right to how do we solve this complex problem. As we move through this series, we will examine the specific roles of special masters in academic divorces, individuals who are appointed to make decisions on highly technical assets. We will dive into the data regarding the long-term career trajectories of divorced academics who chose mediation versus those who chose litigation. Case studies consistently suggest that those who utilize mediation maintain higher levels of research output in the 5 years following a divorce compared to those embroiled in multi-year court battles. This isn't just about saving money. It is about saving a career and a contribution to the global body of knowledge. The promise of this masterclass is clarity in a sea of academic and legal jargon. We are going to look at the potential outcomes of protecting your lab, your grants, and your legacy. We will provide a historical context for why the ivory tower needs a better exit strategy, and how you can apply these principles to ensure that your life's work remains intact, even when your domestic life is undergoing a fundamental transformation. This is not a superficial overview. This is an educational deep dive into the mechanics of professional and personal survival in the modern American university system. This is the first step toward understanding the sophisticated interplay of equity, law, and the pursuit of knowledge. To move from the broad philosophical frameworks of dispute resolution into the granular reality of the university campus, we must address the most significant hurdle in any academic dissolution: the valuation of intellectual property and career-based assets. In the year 2026, the definition of marital property has evolved far beyond the traditional boundaries of real estate and bank accounts. For a modern scholar, the most valuable part of the marital estate might exist entirely in the form of digital code, a half-finished manuscript, or a breakthrough genetic sequence stored in a cryogenic freezer. Traditional litigation is notoriously ill-equipped to handle these abstractions. We have seen historical trends where generalist judges, overwhelmed by the complexities of technology transfer agreements, simply order a 50-50 split of all future royalties, a decision that can stifle innovation and lead to decades of post-divorce legal battles. Mediation, by contrast, treats these assets with the precision of a peer review process. Imagine a scenario involving Dr. Elena Rodriguez, a prominent researcher in 2026 who specializes in CRISPR-based agricultural enhancements at a major land-grant university. Over the course of her 12-year marriage, she has developed a series of drought-resistant seed genes. The university holds the primary patent, but under the institutional intellectual property policy, Dr. Rodriguez is entitled to 30% of all future licensing revenue. In a standard courtroom setting, the opposing counsel might hire a general business valuator who attempts to put a fixed price on these future royalties today. This often results in a massive, upfront buyout figure that the academic spouse cannot possibly afford, potentially forcing the sale of other vital assets like a home or a retirement fund. Through the lens of mediation, the parties can instead engage a technology transfer expert as a neutral third party. This expert can help craft a specialized royalty-sharing agreement that mirrors the university's payout structure, ensuring that the non-academic spouse receives a fair portion of the actual income, if and when it materializes, rather than a speculative and potentially ruinous estimate. This leads us to the concept of the tenure clock and the valuation of the academic career itself. Historical trends in American family law, particularly in jurisdictions like New York, once considered professional degrees and licenses as marital property. While the law has shifted, the concept of enhanced earning capacity remains a central point of contention. Consider the case study of Professor Michael Thompson, who is currently an assistant professor in his penultimate year before tenure review in 2026. If Michael undergoes a traditional adversarial divorce during this period, the discovery process, which involves subpoenas for his internal university reviews, publication records, and grant applications, can be catastrophic for his professional standing. The stress of litigation is a documented factor in decreased research output. Data suggests that academics in high-conflict divorces see a significant dip in their publication citation index during the 3 years surrounding their legal proceedings. In a mediated environment, the focus shifts to preservation. A step-by-step mediation process for someone in Michael's position would first involve a confidentiality agreement that goes beyond the standard court order. This prevents the sensitive details of his tenure file from becoming a matter of public record or a topic of departmental gossip. Secondly, the mediator would facilitate a discussion on the timing of the settlement. Rather than pushing for a resolution during the height of the tenure review cycle, a mediated schedule can be paused or slowed to accommodate the scholar's professional milestones. Potential outcomes here include a trade-off where the non-academic spouse receives a larger share of the current liquid assets in exchange for waiving a claim against the future salary increase that comes with the tenured position. This protects Michael's long-term career trajectory, while providing the other spouse with immediate financial security. We must also perform a deep dive into the unique nature of academic retirement accounts. Most Americans are familiar with the 401k, but the academic world primarily operates on the TACREF system. These accounts are not merely savings vehicles. They are often complex contracts involving traditional annuities that cannot be easily divided or liquidated without significant tax penalties. Historical trends show that many generalist attorneys attempt to split these accounts using a standard qualified domestic relations order, only to have the order rejected by TACREF because it fails to account for the specific rules of the university's plan. In mediation, the parties have the opportunity to bring in a specialized financial neutral who understands the difference between the TA traditional account, which offers historical stability and guaranteed minimum interest rates, and the CREF stock account, which is market-dependent. A step-by-step analysis in mediation would involve calculating the marital portion of each specific subaccount and determining if an offset is possible. For example, rather than splitting a complex annuity that is nearing its payout phase, one spouse might keep the TA contract, while the other takes a larger portion of a standard brokerage account. This prevents the loss of internal death benefits and survivor options that are often stripped away in a clumsy court-ordered split. Another critical area of this discourse is the management of research grants and laboratory accounts. Many principal investigators in 2026 manage multi-million-dollar budgets funded by the National Science Foundation or the National Institutes of Health. To a family court judge, a bank account with a 7-figure balance looks like a marital asset. However, in the eyes of federal law, that money is restricted for research purposes and does not belong to the individual. We have seen case studies where a lack of understanding led to a temporary freeze on research accounts during a divorce, resulting in the loss of graduate student funding and the expiration of time-sensitive biological samples. Mediation allows for a sophisticated audit where the academic spouse can clearly demonstrate the nature of these funds. Potential outcomes include the creation of a clear boundary between personal marital funds and institutional research funds, ensuring that the lab remains operational and that the academic's professional reputation for fiscal responsibility remains untarnished. Furthermore, we must consider the human capital aspect of American academia, the PhD students and postdoctoral fellows. A professor's career is inextricably linked to the success of their mentor. A disruptive litigation process doesn't just affect the two spouses. It has a ripple effect through the entire research group. If a professor is forced to take a leave of absence to deal with court dates, or if their mental health declines due to a scorched earth legal strategy, the progress of their students is stalled. Mediation recognizes this ecosystem. It allows for a holistic approach where the academic spouse's time commitments are respected. Imagine if the mediation sessions are scheduled specifically during the summer months or during a sabbatical, ensuring that the core mission of teaching and research continues without interruption. As we look at the historical data from 2020 to 2026, We see a clear correlation between the method of divorce and the subsequent ability to secure federal funding. Those who engage in collaborative, mediated processes are able to maintain a consistent narrative of professional stability to their granting agencies. They avoid the public disclosures that can lead to internal university investigations or fitness for duty reviews. This is the deep dive reality of the ivory tower. Your professional identity is your most valuable currency, and mediation is the vault that protects it. But what happens when the conflict isn't just about money or patents? What happens when the divorce threatens to trigger a university-wide ethics investigation or a conflict of interest crisis? In the next part of our masterclass, we will explore the intersection of HR policy and family law. We will look at how mediation can navigate the treacherous waters of departmental politics, shared faculty social circles, and the specific challenges of dual-career academic couples, the so-called two-body problem. We will examine what happens when both spouses are vying for the same departmental resources, or when one's tenure depends on the other's professional silence. The complexity only deepens from here. The two-body problem in American academia is a term often used to describe the difficulty of two partners securing faculty positions within the same geographic region. But in 2026, we are seeing this problem take on a far more litigious and complex form during the process of marital dissolution. When both spouses are embedded within the same university ecosystem, the divorce is not just a family matter. It becomes a matter of departmental governance and institutional risk. Imagine if Professor David Chen and Dr. Sarah Miller, both high-achieving faculty members in the Department of Mechanical Engineering at a Tier 1 research university, decide to end their marriage. In a traditional courtroom setting, the adversarial nature of litigation would likely force their professional dirty laundry into the public record. Any allegations of professional negligence, skipped office hours, or even minor lapses in lab safety could be used as leverage for alimony or child custody. In the insular world of academia, such public disclosures are professional suicide. Historical trends indicate that when academic couples engage in public legal battles, the university's Human Resources Department often feels compelled to intervene, especially if the conflict begins to disrupt departmental harmony or student mentorship. Through the lens of mediation, David and Sarah can avoid this institutional intrusion by drafting what is known as a professional operating agreement. This is a step-by-step framework, separate from their financial settlement, that dictates how they will interact within the university halls. For instance, the agreement can specify that both parties will refrain from serving on the same hiring committees or tenure review boards for a set period. It can establish a clear protocol for departmental meetings, such as ensuring they do not sit directly across from one another, or that they alternate attendance at social functions. These might seem like minor details, but in the high-pressure environment of 2026 academia, these mediated boundaries prevent the awkwardness that often leads to one spouse being marginalized by colleagues who feel forced to choose sides. We must also look at the high-stakes reality of shared intellectual capital. Imagine if David and Sarah have spent the last decade co-authoring papers and co-managing a federal grant from the Department of Energy. In a litigation scenario, a judge might view their shared research data as a divisible asset, but research data is not a house that can be sold at auction. If a court orders a freeze on their shared server or prevents one party from accessing a proprietary database during the discovery phase, years of scientific progress could be lost. Case studies from 2026 show that mediation allows for a more nuanced approach, such as creating a data access continuity plan. This plan, facilitated by a mediator with an understanding of federal grant regulations, ensures that both researchers can continue their work independently, while the financial value of any resulting patents is partitioned in the background. It moves the focus from blocking access to ensuring research viability, which is essential for maintaining the grant funding that pays for their graduate students and laboratory overhead. This leads us into the treacherous waters of mentorship and the graduate student experience. In the American university system, graduate students and postdocs are often dependent on the stability of their principal investigator's professional and personal life. When a faculty couple divorces, the lab can quickly become a polarized environment. Historical trends show that students in such environments often suffer from delayed graduations, lost funding, or being drafted into the interpersonal conflict. A mediated solution in 2026 involves a student protection protocol. This is a specific part of the mediation process where the couple agrees to a non-disparagement clause that explicitly covers interactions with students. They might agree on a joint statement to be released to their respective lab groups, emphasizing that their professional collaboration will continue despite the personal change. By handling this in a private mediation, they prevent the rumors that often lead to top-tier talent fleeing the lab for more stable environments. Furthermore, we must address the potential outcomes of tenure-track silence. Imagine if one spouse is tenured and the other is an assistant professor approaching their 6th-year review. In an adversarial divorce, the tenured spouse holds a massive amount of informal power. They could, theoretically, influence the tenure committee through private conversations or subtle professional sabotage. In a traditional court, it is almost impossible to prove such quiet interference. However, in mediation, this power imbalance can be addressed head-on. The parties can negotiate a tenure support addendum. This might include an agreement where the senior spouse recuses themselves from all formal and informal discussions regarding the junior spouse's career for a period of 5 years. It might also involve a financial clawback provision. If the junior spouse is denied tenure, and it can be shown that the senior spouse violated the non-interference agreement, the financial settlement is automatically adjusted to compensate for the lost earning potential. This creates a tangible incentive for professional decorum that a standard divorce decree simply cannot provide. In the year 2026, we are also seeing an increase in university-sponsored mediation services, though these must be navigated with extreme caution. While university ombudsmen can provide a starting point, their primary loyalty is to the institution, not the individual faculty members. This is why private, specialized mediation is becoming the gold standard for academic divorces. A private mediator can help the couple navigate the specific conflicts of interest that arise when two people share a budget or a laboratory footprint. Step by step, the mediator helps the couple audit their professional entanglements. They look at equipment buyout options, for example. If Sarah needs a specific mass spectrometer that was purchased with David's startup funds, the mediation can facilitate a fair market transfer of that equipment's usage rights without involving the university's legal counsel. This keeps the transaction quiet and keeps the university administration out of the couple's private affairs. The data suggests that for dual-career academic couples, the financial cost of a public divorce is often secondary to the reputational cost. Historical trends from the early 2020s show that faculty members who went through high conflict, public divorces were significantly less likely to be recruited by other institutions for senior leadership roles like department chair or dean. The perception of being a liability or bringing drama to a new campus is a major career killer in 2026. Mediation acts as a reputational shield. By keeping the details of the split within the confines of a confidential office, the couple maintains the narrative of professional stability. They are seen as adults who can handle complex transitions with the same intellectual rigor they apply to their research. As we continue this masterclass, we have to look beyond the department walls. The academic career is global, and the American scholar is often required to move between institutions, countries, and continents. This brings us to the logistical nightmare of the sabbatical and the Global Research Fellowship. What happens when a mediated agreement in the United States meets the jurisdictional reality of a research year in Zurich or a field study in the Amazon? How do you maintain a shared custody arrangement when one parent's career requires 3 months of international travel every year? In the next part, we will dive into the sabbatical trap. We will explore how to draft international mobility clauses that protect both the scholar's research requirements and the children's stability, and why the standard American custody model is completely broken for the modern, mobile academic. The challenge of the global scholar is a high-stakes puzzle that only deep-dive mediation can solve. The challenge of the global scholar is a high-stakes puzzle that only deep-dive mediation can solve. To understand why the standard American custody model, the typical alternating weekends and shared holidays, fails the academic professional so spectacularly, we must look at the structural requirements of the 2026 research landscape. In many Tier 1 universities, international mobility is not a luxury. It is a prerequisite for advancement, tenure, and continued grant eligibility. If a historian is not in the archives in Paris, or a geologist is not at the field site in the Andes, their career does not just stall, it begins to atrophy. Historical trends show that when these cases reach a standard family court, judges often apply a domestic stability test that prioritizes a consistent physical residence in a single school district. This creates a binary choice that often results in the academic parent either forfeiting their career growth or losing significant parenting time. Imagine a case study involving Dr. Julian Vance, a tenure-track researcher in 2026, who has just been awarded a prestigious fellowship at the Max Planck Institute in Germany. Julian's divorce is being finalized in a state like Massachusetts or California. His ex-spouse, Chloe, is a professional whose career is rooted in their home city. In a traditional litigation scenario, if Julian tries to bring their 7-year-old son with him for the academic year, he faces a relocation battle that could take 18 months to resolve. By the time the court reaches a decision, the fellowship opportunity has passed. If he goes alone, he risks a court ruling that his absence constitutes a voluntary abandonment of his primary caregiving role, potentially permanently altering his custody rights. Mediation offers a third way through the creation of an academic mobility clause. This is a step-by-step framework designed to handle the ebb and flow of a scholar's international obligations. Instead of a rigid weekly schedule, a mediated agreement for Julian and Chloe might utilize an elastic custody framework. This model, which we are seeing more frequently in 2026, treats time as a multi-year bank rather than a weekly quota. The first step in this process is a 5-year audit of Julian's research cycle. Mediation allows the parties to identify the windows of high mobility, such as upcoming sabbaticals or field seasons, and balance them against the child's developmental stages. In Julian's case, potential outcomes of a mediated settlement could include a block time allocation. During the year he is in Germany, his son might spend the entire summer and every school break with him in Europe, facilitated by a travel escrow account. This account, funded proportionally based on their 2026 income levels, specifically covers the rising costs of international flights. The step-by-step detail of such an agreement would include specific provisions for virtual presence protocols. In 2026, this goes beyond a simple video call. It involves mediated agreements on digital participation in school plays, homework sessions via shared holographic or immersive interfaces, and a commitment to maintain a consistent time zone-adjusted routine. Historical trends in mediation also show the importance of the travel stipend offset. For an academic, the cost of maintaining a relationship with a child across oceans is a significant financial burden that traditional alimony or child support calculators often ignore. A deep dive mediation will calculate the projected cost of international travel for both the parent and the child over a 3-year period. Rather than Julian paying a higher monthly support amount, the mediated agreement might redirect a portion of those funds into a dedicated travel fund, ensuring that the child's right to see both parents is not compromised by the fluctuating costs of transatlantic transit. Another critical layer is the trailing spouse valuation. In many academic marriages, one partner has moved multiple times to support the other's pursuit of tenure. By 2026, the social and legal recognition of this sacrifice has deepened. In a courtroom, this is often argued as a reason for permanent alimony, which can lead to high conflict proceedings. In mediation, this is addressed through a career transition fund. Instead of a never-ending monthly payment that creates a permanent financial link between the ex-spouses, the parties can negotiate a lump sum investment into the non-academic spouse's own professional development or a higher percentage of the home equity. This recognizes the historical data that suggests non-academic spouses often face a significant earning gap due to multiple relocations, but solves it in a way that allows both parties to move forward independently. Consider the imagine-if scenario where the academic parent is the primary caregiver, but their research requires them to be in the lab until midnight for weeks during a critical experiment phase. A traditional court might view this as a lack of stability and award more time to the other parent. In mediation, the couple can create a lab phase contingency. This is a specific part of the parenting plan that automatically shifts certain responsibilities to the other parent during identified periods of high-intensity research, with a built-in make-up time provision that returns those hours to the academic parent during the summer or between semesters. It treats the academic career not as a 9-to-5 job, but as a seasonal profession, similar to how the legal system handles professional athletes or agricultural workers, yet tailored for the intellectual rigors of the university. Step by step, a high-level mediation also tackles the jurisdictional complexity of the global scholar. If an American professor moves to a university in the UK or Singapore, which court has the right to modify the custody order in 2028 or 2030? Historical trends show that without a mediated jurisdictional consent agreement, these families often end up in expensive international legal battles under the Hague Convention. A mediated settlement in 2026 will include a clause where both parties agree that the original U.S. court retains exclusive jurisdiction, regardless of where the academic's career takes them. This provides a level of legal certainty that a standard court order rarely guarantees. The depth of this discourse must also cover the educational travel addendum. For an academic parent, travel is often educational. Mediation allows for the inclusion of clauses that define international research trips not just as parental time, but as educational enrichment for the child. This can influence how school absences are handled and how the costs are shared. Data from 2026 indicates that children of global academics who maintain consistent contact with both parents during international transitions show higher levels of linguistic and cultural competency, a potential outcome that mediation intentionally fosters. We are moving into an era where the ivory tower is no longer a stationary fortress. It is a network of global nodes, and the academic family must be equally flexible. Mediation provides the tools to build a custom-made legal bridge between the stationary demands of the American legal system and the nomadic requirements of modern scholarship. It is the only way to ensure that the pursuit of tenure does not come at the cost of the parental bond. But as we solve the puzzle of global mobility and custody, a darker and more complex shadow begins to emerge over the academic divorce. It is the financial skeleton in the university closet. The intersection of personal dissolution and federal tax audits, university-held housing loans, and the complex valuation of a startup born in a campus incubator. What happens when the university itself owns the house you live in and the divorce triggers a move-out clause? What happens when your 2026 tax returns are scrutinized because of a mix of personal and research-related spending? In the next part of our masterclass, we will dive into the financial shadow. We will explore how to decouple your personal life from the university's institutional grip, and why a simple financial disclosure can lead to a departmental audit you never saw coming. The stakes move from the home to the very foundations of your financial identity. The financial identity of a tenured professor in 2026 is often so deeply intertwined with their institution that a divorce does not just threaten their bank account, it threatens their very housing and credit stability. To understand the depth of this shadow, we must look at the specific mechanisms of university-assisted housing programs. In many elite American institutions, faculty members are offered specialized mortgage programs or subsidized housing that is contingent upon their employment, and occasionally, their marital status as defined at the time of the loan's inception. Historical trends show that these faculty mortgages often feature interest rates significantly lower than the market average, but they come with restrictive covenants. Imagine a case study involving Dr. Marcus Thorne, a senior researcher at a prominent university in the Pacific Northwest. In 2026, Marcus and his spouse, Lydia, live in a 4-bedroom home purchased through a university-run loan program. The terms of this program stipulate that the loan is only valid as long as the primary faculty member occupies the home as their principal residence. If a traditional court orders Marcus to move out while Lydia and the children remain in the home during a protracted legal battle, the university may have the right to call the loan due in full or escalate the interest rate to a standard commercial level. This potential outcome could result in a monthly payment increase of thousands of dollars, effectively forcing a sale during a period of emotional and professional transition. Mediation provides a step-by-step pathway to navigate this institutional trap. In a mediated setting, Marcus and Lydia can involve a university housing liaison as a neutral consultant to explore a forbearance agreement or a temporary waiver of the residency requirement. A mediated settlement might include a nesting arrangement, where the parents rotate in and out of the university's subsidized home while the children remain stationary. Because this is handled privately, the university administration is often more willing to provide flexibility than they would be if they were served with a subpoena in a public litigation. Historical data suggests that institutions are risk-averse. They prefer a quiet, mediated resolution that keeps their faculty member productive, rather than a public legal dispute that could highlight the complexities of their internal housing policies. The complexity of the financial shadow extends into the world of academic startups and campus incubators. By 2026, the bridge between the laboratory and the marketplace has become a primary source of wealth for many American scholars. Imagine if Dr. Thorne has spent the last 5 years developing a sustainable energy patent within a university-sponsored incubator. The startup, ThorneTech, has no current revenue but has just secured a second round of venture capital funding. In a traditional divorce, the valuation of this startup would be a battlefield. Forensic accountants would attempt to place a current dollar value on speculative future technology, often leading to a situation where the academic spouse is forced to trade away their entire retirement portfolio just to keep their equity in the company they founded. A deep dive mediation approach handles this by utilizing what is known as a variable distribution clause. Step by step, the mediator works with the couple and a specialized valuation expert who understands the unique life cycle of an academic startup. Instead of a high-stakes, upfront valuation, they might agree to a formula where the non-academic spouse receives a percentage of the actual net proceeds if the company is sold or goes public within a certain time frame. This potential outcome protects the scholar's ability to continue the research without the burden of an immediate, massive debt to their ex-spouse. Case studies from 2026 indicate that this collaborative approach prevents the predatory litigation tactics that often lead to the collapse of a startup during its most vulnerable growth phase. We must also address the silent threat of the departmental audit. In American academia, the line between personal professional expenses and university-funded research spending can sometimes become blurred. A professor might use a research grant to cover a trip to a conference in Hawaii, and their spouse might accompany them, with personal and professional costs mixed on a single credit card statement. In a high-conflict litigation, the discovery process is absolute. An angry spouse's attorney can demand every receipt and travel log from the last 7 years. If these records reveal even a minor inconsistency in how grant funds were utilized, it can trigger an internal university investigation or, in extreme cases, a federal audit by the granting agency. Historical trends show that such disclosures during a divorce have led to professors being placed on administrative leave or losing their principal investigator status. Mediation acts as a financial firewall. Because the process is confidential and the exchange of documents is voluntary and collaborative, the parties can conduct a shadow audit. This involves hiring a neutral forensic accountant to review all joint and research-related accounts before any formal disclosures are made. If discrepancies are found, they can be corrected or accounted for within the private settlement, effectively neutralizing the risk of a career-ending institutional audit. This is not about hiding information. It is about managing the sensitive intersection of federal regulations and personal finance in a way that preserves the primary source of income for both parties. Furthermore, we must look at the specific tax implications of academic life in 2026. Many professors receive a portion of their compensation in the form of tuition remissions for their children or housing allowances. These are often treated as non-taxable benefits by the university, but can be viewed as imputed income by a family court. A standard alimony calculator might see Dr. Thorne's tuition benefit, worth $50,000 a year, as liquid cash, leading to an alimony award that Thorne cannot actually pay with his net salary. Mediation allows for a granular analysis of these benefits. A mediated agreement can specify that the tuition benefit is a direct credit toward child support obligations, rather than a basis for increasing alimony. This ensures that the actual cash flow of the academic professional is not strangled by a court's misunderstanding of university compensation structures. Step by step, the mediation process also addresses the valuation of the bibliography and the academic brand. In 2026, a professor's public profile, their books, their speaking engagements, and their digital presence has a tangible market value. We are seeing case studies where spouses are claiming a marital interest in the future royalties of books that haven't even been written yet, based on the historical success of the author. Mediation facilitates a realistic discussion on the shelf life of academic work. It acknowledges that while a textbook might generate revenue today, its value depreciates rapidly as new editions are released. Potential outcomes in mediation often include a declining royalty split, where the non-academic spouse's share decreases over time, as the author spouse exerts more post-divorce effort to maintain the work's relevance. As we move through this discourse, it becomes clear that the academic professional is not just an employee. They are a small, highly regulated business entity. The divorce process must be adapted to this reality. We have explored the housing traps, the startup valuations, and the audit risks that haunt the financial lives of scholars. We have seen how mediation provides the specialized tools to decouple the individual from the institution without destroying the career that sustains them both. But there is one final, deeply personal layer to the academic divorce that even the best financial mediation cannot fully resolve on its own. It is the social and political landscape of the university itself. What happens when your ex-spouse is the best friend of your dean? What happens when the social fabric of the campus, the dinner parties, the faculty clubs, and the shared committees, becomes a minefield of divided loyalties? In the next part of our masterclass, we will dive into the social and political fortress. We will look at how to draft social non-disparagement agreements that actually work in a campus setting, and how to manage the fallout of a divorce in an environment where your personal reputation is your most critical professional asset. The politics of the faculty lounge are often more dangerous than the laws of the courtroom, and you need a strategy to survive them. The social and political fortress of the university is often where the most significant, albeit invisible, damage of a divorce occurs. In the year 2026, the American academic environment has become hyper-attuned to interpersonal dynamics, where the concept of a safe and inclusive workplace extends into the private lives of its faculty. For a scholar, the departmental lounge, the faculty senate, and even the local coffee shop where colleagues gather are not just social spaces. They are the arenas where professional capital is traded. Historical trends indicate that when a divorce becomes a topic of departmental gossip, the parties involved often suffer from a subtle but measurable decline in their social influence, which can lead to a loss of key committee assignments, fewer invitations to collaborative research projects, and even a cooling of relationships with university leadership. Imagine if Professor Robert Miller, a leading light in the Department of Sociology at a top-tier university in 2026, finds himself in the middle of a contentious dissolution from his spouse, Julianne. Julianne is not a faculty member, but she is the daughter of a major university donor and a fixture in the local philanthropic community. In a traditional adversarial divorce, Robert's legal team might seek to aggressively protect his assets, but every aggressive move in the courtroom could trigger a political backlash on campus. If Julianne feels slighted, her social circle, which includes the Dean of Arts and Sciences and several members of the Board of Trustees, might begin to view Robert as a persona non grata. This is the reality of the political fortress. Your legal victory could be your professional funeral. Mediation provides a sophisticated set of tools to navigate this minefield, starting with the Social Conduct Addendum. This is a step-by-step mediated agreement that goes far beyond a standard legal non-disparagement clause. In 2026, a standard clause is insufficient because it does not account for the nuance of academic communication. A mediated social agreement for Robert and Julianne would specifically define prohibited behaviors in the context of the university ecosystem. It might include a provision that neither party will discuss the details of the divorce with university donors, administrators, or faculty members. Step by step, the mediator helps the couple identify the specific social nodes where their lives intersect and creates a protocol for each. For example, they might agree on a script for when colleagues inevitably ask how they are doing, a neutral, pre-approved response that signals the matter is private and settled, thereby starving the gossip mill of its fuel. Case studies from recent years show that the digital footprint of a divorce is particularly dangerous in academia. Scholarly life in 2026 involves a high degree of public engagement on platforms like academic Twitter, ResearchGate, and specialized departmental blogs. A single misinterpreted post or a series of passive-aggressive comments can be screen-captured and circulated through departmental listservs in minutes. Mediation allows for a digital peace treaty. This part of the agreement would dictate that neither party will use their professional platforms to vent, even indirectly, about their personal lives. It might also include an agreement to unfollow or mute one another on specific platforms to avoid the accidental triggers that lead to impulsive posting. Historical trends suggest that faculty members who implement these digital boundaries in their mediation settlements are far less likely to face HR inquiries regarding their online conduct. Another critical element is the committee and institutional recusal plan. In the complex web of university governance, it is highly likely that a divorcing couple, or one spouse and a close friend of the other, will be required to serve on the same search committee, tenure review board, or ethics panel. In a traditional litigation environment, these interactions are left to chance or departmental intervention, which often results in awkward confrontations that embarrass the department chair. A mediated solution involves a proactive audit of all upcoming institutional commitments. Step by step, the mediator works with the couple to identify potential points of friction over the next 3 academic years. Potential outcomes include an agreement where one spouse voluntarily steps down from a high-profile committee in exchange for a specific concession in the financial settlement, or a formal agreement that both will request separate subcommittees from the dean to ensure they are never in the same room for voting or deliberation. This leads to the preservation of donor relations and fundraising capacity. In 2026, senior faculty are often expected to assist in university development efforts. If a divorce is perceived as scandalous or messy, the University Development Office may pull that faculty member from high-stakes meetings with potential benefactors. This is a direct hit to the professor's value to the institution. Through mediation, the couple can create a joint statement for institutional stakeholders. This is not a public document but a confidential memo that can be shared with the dean or the development office if necessary, stating that the parties have reached an amicable, private resolution. This proactive step reassures the university leadership that the faculty member's personal life will not become an institutional liability, effectively neutralizing the risk of being sidelined from prestigious roles. Imagine if the conflict isn't with an external donor, but with a fellow faculty member. In dual-career academic couples, the social circle is often entirely shared. When the split happens, colleagues often feel an intense pressure to take sides, creating a bifurcated department. This departmental tribalism can paralyze research groups and lead to a toxic work environment. Data suggests that departments that endure a public faculty divorce see a decrease in morale and an increase in faculty turnover within 18 months. Mediation addresses this through a social neutrality protocol. The couple agrees to specific rules about social gatherings, such as the annual faculty holiday party or departmental retreats. They might agree to attend at different times or to sit at opposite ends of the room, and more importantly, they agree to explicitly tell their close colleagues that they do not want people to take sides. By taking this off the table in a mediated setting, they preserve the professional health of their entire department. The psychological toll of the faculty lounge tribunal cannot be overstated. Academics are, by nature, analytical and often judgmental. Being the subject of their collective gaze during a legal crisis is a unique form of professional torture. Mediation allows the scholar to maintain their dignity. It moves the resolution of the marriage from a public arena of conflict to a private room of intellectual problem-solving. Potential outcomes include the retention of a professional identity that is untarnished by the labels of victim or aggressor that litigation so often imposes. Step by step, we are building a framework that recognizes the university not just as an employer, but as a totalizing social and political world. We have looked at how to silence the gossip mill, protect donor relations, and navigate the treacherous waters of departmental committees. We have seen how a mediated social agreement acts as a shield for the most precious asset a scholar possesses, their reputation. But as we secure the social and political fortress, we must eventually confront the most technical, and often the most frustrating part of the entire process. It is the part where the abstract concepts of law and academia meet the cold, hard reality of federal regulation. We are talking about the mechanics of the actual mediation sessions themselves, the specific documents you need, the specialized experts you must hire, and the secret language of academic QDROs that can make or break your retirement. What happens when the mediator doesn't understand what a 403B is compared to a 401k? What happens when your university's legal counsel refuses to cooperate with your mediated settlement? In the next part of our masterclass, we will dive into the engine room of mediation. We will explore the technical blueprints for an academic settlement and why your choice of mediator could be the most important career decision you make in 2026. The technicalities are where the deal is won or lost, and we are going deep into the fine print. Finding the right pilot for this technical flight is the first step. In the year 2026, the marketplace for mediators has branched into hyper-specializations, and nowhere is this more critical than in the academic sector. A standard family law mediator might be excellent at calculating the value of a small business or a suburban home, but they often stumble when faced with the unique deferred compensation structures and institutional bylaws of a large research university. Historical trends show that settlements mediated by generalists often require multiple post-divorce amendments because the language used was incompatible with the university's benefits office. This technical breakdown is where your financial future is either secured or compromised. Imagine a case study involving Samuel Green, a tenured professor at a major East Coast university in 2026. Samuel decided to use a standard neighborhood mediator to save time. The mediator treated Samuel's 403B retirement account exactly like a corporate 401k. They drafted a split that didn't account for the fact that Samuel's university provides a significant employer match that vests on a specific 5-year cycle. Because the mediator didn't understand the nuance of the vesting schedule, the final decree ordered a transfer of funds that hadn't legally vested yet. This triggered an internal university audit and a massive IRS tax penalty that could have been avoided with a more nuanced timeline. In mediation, a specialized professional would have identified this vesting cliff and structured the transfer to occur 45 days later, saving the couple nearly $40,000 in unnecessary fees. Step by step, the technical engine room begins with the document gathering phase, specifically the Summary Plan Description or SPD. In 2026, these documents are no longer simple pamphlets. They are digital repositories outlining exactly how the university handles retirement, life insurance, and survivor benefits. For an academic, the SPD is the primary governing document of their wealth. A deep dive mediation requires both parties to sit down with a neutral financial expert who can translate the academic jargon. We are looking at specific categories: the 403B tax-sheltered annuity, the 457B deferred compensation plan, and the often overlooked 401A defined contribution plan. The most complex component of this engine is the Qualified Domestic Relations Order, or QDRO. This is the legal instrument used to divide a retirement account without triggering immediate taxes. In the world of 2026 academia, the QDRO process is a minefield. Historical data suggests that TACREF, one of the largest providers for academic institutions, rejects nearly 30% of court-ordered QDROs on the first submission because the language is too generic. In a specialized mediation, the couple does not wait for a judge to sign a blind order. Instead, they engage in a pre-approval process. Step by step, the mediator facilitates a dialogue with the TACREF legal department, sending draft language to be vetted before the divorce is ever finalized. This potential outcome ensures that the moment the divorce is granted, the accounts are split cleanly and accurately, providing immediate liquidity to both parties. We must also perform a deep dive into the valuation of the master's and PhD tuition remission benefits. For a faculty member in 2026, this is often the single most valuable non-cash asset in the marriage. If the couple has children nearing college age, the university may provide free tuition worth over $100,000 per year. In a traditional litigation, an adversarial attorney might argue this is a future gift with no present value. In mediation, we treat it as a calculable marital asset. Imagine if the academic spouse, Sarah, keeps a larger portion of the home equity in exchange for a binding agreement that the children will utilize her tuition remission benefit. This is a strategic trade-off. The non-academic spouse, Thomas, receives immediate capital, while Sarah preserves her cash flow during the children's college years. This level of granular negotiation is impossible in a courtroom where the judge is restricted by rigid state-mandated asset tables. Then there is the issue of the sabbatical accrual and service credits. In 2026, many universities have moved to a points-based system for sabbatical eligibility. These credits represent a future period of full salary without the obligation to teach. Case studies from recent academic dissolutions show that these credits are increasingly being viewed as a form of deferred compensation. If Professor Green has accrued 6 years of service toward a 1-year sabbatical, that time has a massive financial value. Mediation allows the couple to decide how to handle this. Potential outcomes include an alimony offset where the academic spouse pays less during their sabbatical year, acknowledging that their focus will be on research that will eventually benefit both parties through future book royalties or grants. Furthermore, we must address the institutional clearance step. In American academia, the university is more than just an employer. It is a regulatory body. A successful mediation in 2026 involves a tripartite communication between the couple, their mediator, and the university's Office of General Counsel or Human Resources. While the university legal team does not represent either spouse, they are the gatekeepers of the benefits. A specialized mediator will ensure that the settlement complies with the university's specific conflict of interest policies. For example, if the divorce involves a shared laboratory or a joint research grant, the mediation must produce a document that the university's research office will actually accept. Without this institutional clearance, the couple may find themselves in a situation where they have a legal agreement that their university refuses to implement, leading to a new round of expensive legal battles. The technical depth of this process also extends to the valuation of the academic brand and the bibliography. By 2026, a professor's published works and their associated digital intellectual property are tracked by sophisticated AI-driven valuation tools. We are seeing historical trends where spouses are seeking a percentage of the future earnings of a textbook or a series of online course modules developed during the marriage. Step by step, the mediator helps the couple navigate the shelf life of these works. They look at the citation impact factor and the historical decay of royalty payments. A mediated agreement might include a sunset clause, where the non-academic spouse's interest in the royalties diminishes by 20% every 2 years, reflecting the fact that the author must constantly update the material to keep it profitable. This recognizes the marital contribution while protecting the scholar's post-divorce labor. This is the reality of the engine room. It is where the abstract concepts of fairness meet the cold, hard requirements of federal tax codes and university bylaws. We are building a custom-designed financial vehicle that can survive the transition from a joint household to two separate professional lives. It requires a level of detail that traditional litigation simply cannot provide. But as we master the technicalities of the retirement accounts and the tuition remissions, we have to look at the human element that often drives these technical decisions. We are entering a period in 2026 where the gray divorce is becoming the dominant trend in American academia. What happens when the professor is no longer looking to build a career, but to exit one? What happens when the title of emeritus is on the line, and the retirement is not a distant goal but a present reality? In the next part of our masterclass, we will dive into the legacy and the exit. We will explore the specialized strategies for senior faculty, the unique challenges of dividing a 40-year academic estate, and why the final years of a career are the most dangerous time to engage in a legal battle. The stakes are shifting from the bank account to the very legacy of the scholar. The transition from building a career to preserving a legacy is the defining characteristic of the gray divorce in American academia. In 2026, we are observing a significant increase in marital dissolutions among faculty members over the age of 60, a demographic often referred to as the silver scholars. For these individuals, the divorce is not about future earning potential or tenure tracks. It is about the final distribution of a lifetime of intellectual and financial accumulation. Historical trends suggest that for senior faculty, the university is not just an employer, but a primary component of their identity and estate. When a marriage of 30 or 40 years ends, the legal system often struggles to separate the scholar's institutional status from the marital property. Imagine a case study involving Dr. Abraham Sterling, a world-renowned physicist at a prestigious laboratory in 2026. Abraham is 71 years old and is transitioning into emeritus status. His spouse, Catherine, has been an integral part of his social and professional world for 4 decades. In a traditional litigation, a court might look at Abraham's retirement package and see a standard pension. However, in the high-level mediation of 2026, we recognize that an emeritus title brings with it a suite of non-cash benefits that have immense value. These include continued access to university health plans, which are often far superior to Medicare, office space, research laboratory access, and even the right to apply for grants as a principal investigator. Step by step, the mediation for a senior academic must address the emeritus benefit valuation. If Abraham retains these institutional perks, does Catherine lose her access to the university's high-tier health insurance? Historical data from the mid-2020s shows that many university plans allow for the continued coverage of a former spouse if the divorce decree is drafted with specific institutional language. A mediator specializing in academic exits will work with the university's benefits office to ensure that Catherine's health security is not compromised by the divorce, which in turn reduces the need for Abraham to provide higher monthly alimony to cover her private insurance costs. Potential outcomes here include a collaborative agreement where Abraham's emeritus office space is used as a neutral site for the exchange of personal property, maintaining a sense of dignity that a public storage unit would not afford. The complexity of the academic estate also involves the division of physical intellectual property, specifically the personal library and research archives. For a scholar like Abraham, a 40,000-volume library collected over 40 years is not just a pile of books. It is a curated professional asset. In 2026, the valuation of such libraries is handled by specialized AI-driven appraisers who can track the market value of rare editions and signed manuscripts. In a standard courtroom, these would likely be valued as household goods, often resulting in their liquidation at a fraction of their worth. Mediation allows for a more sophisticated solution. A common case study in 2026 involves the creation of a charitable remainder trust. Abraham and Catherine might agree to donate the library to the university as a joint gift, securing a significant tax deduction that benefits both parties while ensuring the collection stays intact and Abraham's name remains on the library wing. This turns a potentially bitter asset division into a shared legacy achievement. Furthermore, we must address the survivorship benefit trap. In many academic retirement systems, a faculty member must choose a pension payout option at the time of retirement. If Abraham chose a joint and survivor annuity 10 years ago, he may not be able to change that beneficiary even after a divorce. This means Catherine would receive a portion of his pension even after he passes away. Historical trends show that litigation over these locked-in benefits often results in decades of resentment. In mediation, the parties can look at the actuarial value of that survivorship benefit and use it as an offset. For example, Catherine might agree to take a smaller portion of the current liquid savings in exchange for keeping her right to the survivor annuity. This step-by-step calculation, performed by a neutral actuary during the mediation, ensures that both parties understand the long-term cash flow, and that Abraham is not left with a retirement income that is insufficient for his own needs. Then there is the issue of the endowed chair and naming rights. In 2026, many senior faculty hold positions funded by private donors or family foundations. If a scholarship or a departmental chair is named after both the husband and wife, a divorce can create an institutional nightmare. Imagine if the Stirling chair in theoretical physics suddenly becomes the subject of a legal dispute. University development offices are notoriously sensitive to the optics of donor-funded positions. Mediation provides a private forum to negotiate the institutional branding of the legacy. The couple can agree on a naming protocol that respects their history while reflecting their new reality. Potential outcomes include the rebranding of the chair to a neutral family name or a formal agreement that both will continue to participate in the chair's annual gala as co-benefactors, preserving their social standing in the university community. We must also perform a deep dive into the phased retirement program. By 2026, many American universities have implemented programs that allow senior faculty to reduce their workload over 3 to 5 years while maintaining full benefits. This bridge period is a critical time for mediation. Because the income level changes each year during the phase-out, a standard alimony order can quickly become outdated. A mediated settlement can include a sliding-scale alimony formula that automatically adjusts based on Abraham's actual university compensation each year. This prevents the need for the parties to return to court every time a new phase of the retirement kicks in, saving thousands in legal fees and maintaining a cooperative relationship. Another layer of the gray divorce is the division of future royalties from a lifetime of work. For a senior academic, a textbook may be in its 10th edition. While Abraham may not be writing new chapters, the royalties continue to flow. Case studies in 2026 indicate that these royalties are often treated as a declining asset. Mediation allows for the creation of a royalty sunsetting schedule. Instead of a permanent 50-50 split, the agreement might stipulate that Catherine receives 50% for the first 3 years, dropping to 25% for the subsequent 3, and then sunsetting entirely. This recognizes the marital effort put into the early editions while acknowledging that Abraham's continued professional reputation is what keeps the book relevant in the current market. Step by step, the mediation for the academic exit is about decoupling two lives that have been professionally and personally fused for the better part of a century. It requires an understanding that for the senior scholar, the university is the house they never left. Protecting their standing in that house is often more important than the cash value of the furniture. We have looked at the health insurance complexities, the library valuations, the survivor benefits, and the naming rights. We have seen how mediation protects the legacy that litigation would likely dismantle. But as we conclude the technical and professional aspects of this discourse, we must finally turn to the most volatile element of any academic divorce: the intellectualized emotion. Scholars are uniquely adept at using logic to mask deep-seated emotional trauma, and this can be the ultimate deal-breaker in a mediation room. What happens when a professor treats their ex-spouse like a failing student? What happens when the drive for accuracy becomes a weapon of control? In the next part of our masterclass, we will dive into the psychology of the scholar. We will explore the common personality archetypes that appear in academic mediation, how to handle the expert witness syndrome, and why the most brilliant minds often struggle the most with the simple act of compromise. The emotional deep dive is the final frontier of the academic divorce. To understand the psychology of the scholar in the mediation room, we must first acknowledge the cognitive bypass that occurs when a high-functioning intellectual is faced with an emotional crisis. In the year 2026, we have identified a consistent historical trend among American academics: the tendency to treat the dissolution of a marriage as a research project rather than a human transition. This intellectualization of emotion is a defensive mechanism where the scholar uses their immense analytical capacity to distance themselves from the pain of the split. Instead of discussing the heartbreak of a shared life ending, they present the mediator with a 30-page comparative analysis of cost of living adjustments in university towns. While this level of detail is helpful for the technical engine room we discussed earlier, it often acts as a barrier to the genuine compromise required for a successful settlement. Imagine a case study involving Dr. Jonathan Reed, a leading expert in decision theory at a top-tier California university in 2026. Jonathan approached his mediation with the same rigor, He applied to his published papers. He arrived with a specialized algorithmic model he had developed to track the domestic contributions of both spouses over their 15-year marriage. He had accounted for every dish washed, every school run made, and every hour spent proofreading his spouse's professional emails, all adjusted for the inflation of emotional labor. In Jonathan's mind, the model was unassailable. He wasn't trying to be cruel. He was trying to be correct. Potential outcomes for someone like Jonathan often involve a complete stalemate. When his spouse, Megan, responded with a request for simple empathy regarding the loss of their family unit, Jonathan viewed her emotionality as a lack of data. This is the rational actor fallacy, the belief that if you can prove your position is logically superior, the other party is obligated to concede. In mediation, logical superiority does not exist, only mutual acceptability does. Step by step, a specialized mediator in 2026 must deconstruct what we call the expert witness syndrome. This occurs when an academic treats the mediation session like a dissertation defense. They view the mediator as the committee chair and their spouse as the opposing candidate. They use high-level jargon and institutional authority to validate their claims, often inadvertently alienating their partner in the process. Historical data suggests that scholars are more likely than any other professional cohort to appeal to the authority of their title during negotiations. They might say, as a tenured historian, "I can tell you that the historical precedent for this asset split is clear." This attempt to utilize professional prestige to settle a personal dispute is almost always counterproductive. The mediator's job is to shift the scholar from their podium back to the kitchen table. We must also perform a deep dive into the professor-student dynamic that often haunts academic marriages, particularly in cases with a significant age or career stage gap. Imagine a case study involving Dr. Emily Hayes and her non-academic spouse, Mark, in 2026. Emily, a senior administrator and professor, had spent 20 years in a position of authority. In the mediation room, she defaulted to her classroom persona. She would correct Mark's grammar during his opening statement and provide him with feedback on his negotiation style, as if she were grading a sophomore essay. This correctional impulse is a major trigger for high-conflict litigation. Historical trends show that when the non-academic spouse feels patronized or belittled in mediation, they are far more likely to walk out and hire the most aggressive trial attorney they can find, simply to regain a sense of agency. A mediated solution here involves a formal reset of the power dynamic. The mediator must establish ground rules that prohibit the use of pedagogical techniques during the session, ensuring that both parties speak as equals regardless of their institutional rank. Another psychological hurdle unique to this cohort is the narcissism of small differences. Academics are trained to find the 1% of a theory that is incorrect and focus on it with obsessive intensity. In the context of a 2026 divorce, this often manifests as a multi-hour debate over an asset with negligible financial value, such as a specific rare book or a piece of outdated lab equipment. We have seen case studies where a $50,000 legal bill was accrued over the ownership of a shared bibliography that could have been easily duplicated. The scholar's need for precision becomes a weapon of control. A step-by-step psychological intervention in mediation involves the use of a materiality threshold. The mediator encourages the parties to agree, at the start of the process, that any item valued under $500 will be handled through a simple alternating choice method, preventing the analytical mind from getting trapped in the weeds of minutiae. The 2026 landscape also highlights the expert witness bias in child custody. Scholars often believe that because they have researched child development or psychology, they are inherently better parents or have a more valid perspective on the child's needs. This leads to what we call the citation parenting model. Instead of discussing child-specific needs, they cite studies on the benefits of joint physical custody in high IQ households. While research is valuable, it cannot replace the specific emotional knowledge of the individual child. Potential outcomes of this approach include a parenting plan that looks great on paper but fails to account for the child's actual personality or local social ties. Mediation allows for a reality check where the parent is encouraged to put down the peer-reviewed journals and speak as a father or a mother. Furthermore, we must address the fear of the institutional mirror. Many academics in 2026 feel that a failed marriage is a sign of intellectual failure. They worry that if they cannot manage their personal life, their colleagues will question their ability to manage a research group or a department. This leads to a desperate need for a perfect settlement. They want an agreement that they can present as a success story. Mediation provides the necessary confidentiality to fail gracefully. It allows the scholar to process the messiness of a divorce without the fear that their colleagues are watching the proceedings on a public court docket. Historical data indicates that the psychological relief of a private settlement often leads to a significant rebound in professional productivity, as the scholar no longer feels the need to maintain an exhausting facade of personal perfection. As we look at the data from 2024 to 2026, we see that the most successful academic mediations are those where the parties acknowledge their intellectual defenses early in the process. They recognize that their brilliance in the lab or the library does not necessarily translate to brilliance in interpersonal conflict. This humility is the key to unlocking the technical engine room we explored earlier. You can have the best QDRO and the most sophisticated royalty split, but if you cannot move past the need to be the smartest person in the room, the deal will collapse. We have now explored the technical, financial, and psychological landscapes of the academic divorce. We have looked at the global mobility of the scholar, the intricacies of the university retirement system, and the defensive mechanisms of the high-functioning mind. But all of this information is useless without a cohesive plan of action. You need a roadmap that ties every single part of this masterclass together into a final, actionable blueprint. In the 10th and final part of our masterclass, we will reveal the comprehensive academic divorce blueprint. We will walk you through the final 48 hours before you sign your settlement, the secret questions you must ask your university ombudsman, and the one document that almost every academic forgets to include, which leads to disaster 5 years later. We are moving from the discourse to the final execution. The end of this journey is where your new life begins. To move into the final execution phase of this masterclass, we must look at the comprehensive academic divorce blueprint, a structured protocol designed for the high-stakes environment of 2026. This is the moment where theory meets the pavement, and the scholar must transition from a state of analysis to a state of decisive action. The final 48 hours before a mediated settlement is signed are historically the most volatile. Data from the 2025 to 2026 period shows that nearly 15% of mediated agreements in academia fail at this final hurdle because of last-minute institutional anxieties or the discovery of latent ambiguities in the language. To navigate this, we begin with the pre-flight institutional audit. While we have discussed the role of the university ombudsman as a neutral starting point, the final blueprint requires a more tactical interaction. In the year 2026, the savvy academic professional treats the ombudsman not as a confidant, but as a strategic resource for verifying the administrative feasibility of the proposed settlement. Imagine if Dr. Alexander Grant, a senior faculty member in the Department of Public Policy, is preparing to sign his agreement. His final step in the audit is a formal inquiry into the university's specific policy on the continuation of spousal access to digital library resources and institutional software licenses. Historical trends indicate that many academics assume these perks will naturally continue, only to find their ex-spouse locked out of critical research databases 48 hours after the decree is finalized. Dr. Grant's blueprint includes a written confirmation from the University Information Technology Office that a specific, time-limited research affiliate status can be granted to the former spouse. This isn't just a kindness. It is a strategic move to ensure the other party can maintain their own professional trajectory without seeking further financial compensation for lost resources. The second pillar of the final blueprint is the 48-hour forensic review. This is a step-by-step verification of every technical lever we have discussed in this series. You are looking for what forensic accountants in 2026 call the ghost clauses. These are standard legal phrases that work in the corporate world, but create friction in the academic world. For instance, a clause that mandates the immediate liquidation of all joint investment accounts might inadvertently trigger a forced sale of university-specific bonds or restricted faculty investment funds that carry massive early withdrawal penalties. Potential outcomes of a failed forensic review include the loss of nearly 20% of the asset value to taxes and institutional fees. The blueprint requires you to sit with your specialized financial neutral and run a simulation of the transfer process for every single account. You ask the specific question: if this order is served to the University Benefits Office on a Friday afternoon, what happens to the accrual of interest over the weekend? This leads us to the one document that almost every academic forgets to include, which often leads to disaster 5 years later: the Digital Legacy and Grant Transition Addendum. In the 2026 research economy, your data is your currency. Imagine if Dr. Grant has a shared server containing 20 years of longitudinal data on urban development. If the divorce decree does not explicitly define the ownership, access rights, and security protocols for this data, the university's legal counsel may move to sequester the server to avoid potential liability in a domestic dispute. This can halt research for years. The Digital Legacy Addendum provides a step-by-step manual for the university's data steward. It specifies who has read-only access, who can authorize new users, and how the costs of data hosting are divided. Historical trends show that without this document, post-divorce conflicts over intellectual property often end up back in court, costing the scholar hundreds of hours in lost research time. Furthermore, we must address the social reintegration protocol. This is the part of the blueprint that manages the departmental fallout. In 2026, the most successful scholars are those who treat their departmental announcement like a corporate merger. You do not leave the narrative to the rumor mill. Case studies suggest that a short, professional and joint statement sent to the dean and the department chair, once the ink is dry, is the most effective way to neutralize political risk. This statement should not mention the personal reasons for the split, but should focus exclusively on the continuity of professional obligations. It explicitly states that all current research collaborations, student committees, and grant-funded projects will proceed without interruption. By taking this proactive step, you are signaling to the university hierarchy that you remain a stable, productive asset to the institution. We must also look at the sabbatical recapture clause. This is a highly specialized component of the 2026 blueprint. Many professors are eligible for a sabbatical every 7 years, but a divorce in year 5 of that cycle can create a dispute over the value of those 2 accrued years. Potential outcomes of mediation include the non-academic spouse claiming a portion of the sabbatical's salary value. The blueprint solves this by treating the sabbatical not as a bonus, but as a career preservation tool. You negotiate language that classifies the sabbatical as a mandatory professional development phase, ensuring that the full salary remains with the academic spouse to cover the increased costs of international research or publication, while perhaps offering a small, one-time offset in the division of other liquid assets. As we reach the final steps of this discourse, we must consider the 2026 data on the post-divorce professional renaissance. Historical trends show that academics who utilize a deep dive, mediated approach are 30% more likely to secure a major new research grant within the 24 months following their divorce compared to those who engage in litigation. This is not a coincidence. It is the direct result of preserving your mental bandwidth, your institutional reputation, and your financial foundation. You are not just ending a marriage, you are optimizing the next phase of your scholarly life. The final blueprint is a living document. It includes a 5-year review schedule, where you and your former spouse agree to meet with a mediator for a 1-hour check-in every 24 months. This is not to reopen the divorce, but to adjust the technicalities, the QDRO distributions, the tuition remission applications, and the travel schedules, as the university landscape evolves. In 2026, where institutional policies change as fast as the technology they regulate, this adaptability is your greatest protection. You have moved through the ivory tower's most complex legal maze. You have mastered the mechanics of TSREF, the politics of the faculty lounge, and the psychology of the expert witness. You have the blueprint. The end of this series is the beginning of a version of your career that is unencumbered by the weight of unresolved conflict. You are now equipped to handle the intersection of equity and academia with the same precision you apply to your most profound research questions. But even as the paperwork is filed and the departmental statement is sent, a new set of questions begins to emerge for the scholar in 2026. This process has transformed not just your legal status, but your professional identity. How do you leverage this newfound clarity to redefine your research agenda? How does a scholar navigate the dating world of the modern university as a newly single professional in an era of hyper-scrutiny? And most importantly, how do you ensure that the lessons learned in the mediation room translate into a more sustainable and fulfilling academic life? The discourse on the scholar's survival is just beginning, and the next chapter is about more than just surviving the split. It is about the radical reimagining of the academic self in a post-litigation world. The loop is open for your next great discovery.